His free solar panels just stole my home! Your Honor, this is an invisible high-tech epidemic actively targeting every single homeowner across the United States and Canada. Millions of hardworking Americans are spammed with flashy online ads, pop-ups, and door-to-door sales reps promising a $0 utility bill and a government-funded green energy setup every single day. They tell you it's free. They tell you the state is paying for it. But what these multi-billion-dollar green energy conglomerates are hiding in their 50-page digital contracts isn't clean energy. It is a predatory corporate land grab designed to strip the equity clean out of your property. Look at what these power monopolies are doing to our families. My monthly electric bill exploded to over $450. I was drowning just trying to keep the lights on while utility rates skyrocket out of control across the entire nation. And while millions of us are bleeding cash, this man, Robert Gibson, sends his corporate sharks directly to our front doors to exploit our economic desperation. His rep stood on my porch holding an official-looking digital tablet promising immediate permanent relief with absolutely $0 out of pocket. When you are struggling to survive this crushing inflation that sounds like a miracle, he swore it was a routine state grid program, scrolled past the terms in a microsecond, and demanded a digital signature right then and there. I trusted the process. I swiped my finger on the glass. But it wasn't a utility enrollment. This corporate predator slipped a senior priority clean energy tax lien directly onto my property deed. They put the physical panels on my roof for free, yes, but they quietly attached a $25,000 corporate infrastructure fee directly to my county property taxes. It doubled my annual housing costs overnight. In the exact microsecond I couldn't pay their manufactured tax surprise, his private equity investment fund swooped in to trigger an automatic foreclosure on a fully paid off house that took decades of blood, sweat, and tears to own.
Your Honor, if we can kindly step away from Miss Medina's highly emotional courtroom theater and analyze the actual legal and financial framework of this case. My green energy infrastructure firm operates strictly within the boundaries of state and federal law. The plaintiff wanted to transition her home to renewable energy to lower her carbon footprint. We provided the heavy hardware, paid the local labor crews, and she digitally executed a standard state-approved property-assessed clean energy financing agreement commonly known as a PACE loan. The PACE framework is fully authorized by public statutes. The terms of the contract explicitly state in clear legal text that the capital costs of the solar infrastructure are collected via regular county property tax assessments. We did not send her a private bill because the county government issued her standard property tax statement. She failed to satisfy her legal property tax obligation to the state. When a homeowner defaults on a senior priority tax lien, the lien holder has the absolute legal right to liquidate the asset to recover corporate investments. This is standard green energy grid automation. It is not our corporate responsibility to read the font size allowed for a consumer who refuses to do her due diligence.
Mr. Gibson, look at me very carefully. Did your door-to-door sales representative explicitly look this woman in the eye and inform her face-to-face that her annual property taxes would double the following spring? Or did your company deliberately engineer a fast-scrolling digital interface to conceal that massive financial liability, knowing a consumer under extreme financial stress could not possibly comprehend the legal mechanics of a priority property lien?
Your Honor, the entire digital disclosure statement was fully accessible on the tablet interface prior to the electronic signature sequence. The proprietary software does not restrict a user from pausing to read the terms. If a consumer chooses to swiftly swipe through a binding legal contract without consulting financial counsel, the corporation cannot be held liable for their lack of oversight. The contract is ironclad. It was legally recorded at the local county courthouse, and it remains completely binding under corporate finance laws.
Because you engineered the entire digital system so I wouldn't see it! Your Honor, the first asked this court to look closely at Exhibit A, which my legal team has just pulled from the defendant's internal servers. This is not a standard clean energy marketing program. This is a highly sophisticated, predatory algorithmic dragnet that targets every middle-class neighborhood in this country. We legally subpoenaed the internal software logs and training manuals from Mr. Gibson's corporation. Look at the data mapping on the projection screen right now. Their software doesn't just look for houses that get a lot of sunlight. Their proprietary algorithm actively buys public utility data from electric monopolies and cross-references it directly against county property deeds. They specifically instruct their sales crews to target established residential areas with two distinct markers: skyrocketing monthly electric bills and a high concentration of homeowners who own their properties completely free and clear, with absolutely no remaining mortgage debt. They aren't looking for green energy customers, Your Honor. They are looking for pure home equity. They look for vulnerable citizens whose fixed budgets are stretched to the absolute breaking point by inflation. They know that if they attach a massive hidden $20,000 lien to our property taxes, our bank accounts will not stretch far enough to pay the county collector. They intentionally design the default. They don't want the monthly utility repayments because they want the underlying real estate asset. The solar panels are nothing more than a high-tech Trojan horse designed to bypass our front doors, place a legal parasite onto our property deeds, and allow Wall Street investment funds to legally seize residential homes without ever stepping a single foot inside a traditional banking institution.
Your Honor, this is nothing more than unproven conspiracy rhetoric designed to inflame the public and drive click-through rates. The marketing data analytics our corporation utilizes are standard widespread industry practices used by insurance companies, traditional banks, and major online retailers worldwide. Targeting specific demographics who are experiencing high utility costs is efficient modern business practice, not a crime. The unalterable fact remains that the plaintiff signed the digital agreement. The solar infrastructure is operational on her roof. She is receiving the benefit of the power generation, and the financial tax default is a matter of verified public record. You cannot dissolve a legally recorded property lien based entirely on a consumer's emotional regret.
Silence at the defense table. Mr. Gibson, you sit there in your expensive suit and hide behind the word infrastructure while your company systematically strips the generational wealth right out of working-class American neighborhoods. The state authorized green energy financing programs to help everyday citizens reduce their monthly costs, not to provide predatory corporate cartels a legal backdoor to evict hardworking people from paid-off homes over a manufactured tax assessment. I have reviewed the electronic signature metadata submitted by the plaintiff's legal counsel. Your sales software is explicitly programmed to automatically advance past the critical financial disclosure pages in less than 0.4 seconds if the data profile indicates a high probability of home equity. You didn't give her a physical chance to read it. You optimized your digital application flow to execute a legal blindside.
Your Honor, that software metadata is completely misinterpreted. It was a routine technical optimization.
It wasn't an optimization, and it goes even deeper than their software, Your Honor. Look at Exhibit B. We have successfully obtained verified internal text messages and leaked training videos from the door-to-door independent contractors hired by Mr. Gibson's firm. In these messages, the regional sales managers explicitly tell the field reps, if the homeowner asks to see the property tax disclosure page, tell them the tablet screen is lagging and just have them swipe to pass it. They were actively instructed to target stressed working-class families and anyone struggling under the weight of utility bills. In over 300 documented cases in this county alone, contractors went so far as to forge signatures on the final UCC1 fixture filings just to clear the paperwork and collect their $5,000 corporate commission checks. They left a trail of financial destruction behind them. Thousands of families who spent their entire lives building a safe haven for their children are discovering only when they try to pass their home down or refinance their property that a corporate shadow entity technically owns the legal rights to their roof, their land, and their walls. They didn't come to save our environment, Judge Harper, because they came to harvest our land certificates. If you are sitting at home right now watching this video, I need you to listen to me with absolute urgency. Do not look at my face and assume this is just an isolated courtroom battle in a single city. This exact same green energy land grab is happening in broad daylight across Ohio, Florida, California, Texas, and throughout Canada right now as we speak. If a salesman knocks on your front door offering a free solar setup, a state-backed utility reduction program, or asks you to quickly swipe a digital tablet just to verify an estimate, do not touch that screen. They are weaponizing the current inflation crisis and your skyrocketing electric bills as absolute leverage to compromise your property deed. Protect yourself right now. Go to your local county recorder's official website tonight, search your property address, make sure there are no hidden PACE liens or UCC1 fixture filings quietly attached to your deed without your knowledge or explicit consent.
This court has heard enough. The contract executed between the defendant's firm and Miss Medina is hereby declared completely null, void, and unenforceable due to systemic corporate fraud and deceptive marketing practices. The priority property tax lien attached to her deed is ordered to be expunged from the county records immediately, and I am referring this corporate entity to the Federal Trade Commission and the Department of Justice for immediate criminal investigation.